employer handle a situation where the employment contract does not specify a specific age for retirement? It is a small company. There hasn't been any retirees before, and there's nothing specified in the contract of employment. How does the employer handle that? Please advise. Theo, Pretoria.
Oh, thank you, Theo. Advocate Vessels?
Yeah, so I think what's important is to notice that although Section 187(1)(f) of the LRA says that or prohibits the dismissal of an employee on the ground of age, and the section thereafter, 187 subsection 2b, provides an exception, and it says that dismissal of an employee is fair if it's at normal or the agreed retirement age. Now, agreed, I think we all know and understand, is where the date is specified in the employment contract. But normal retirement age, that is really also something, even though the contract, there might not be a written agreement, we can still try and identify what is the normal retirement age. And that is normally the age in an industry or a sector that has become almost a standard practice, where employees are required to retire at a particular age, be it 60 or 65. So what you may find is that some companies offer their employees a pension fund. And even in those pension fund rules, as an example, it indicates that 65 is the date, and the employer has historically always allowed people at 65 to go on retirement. Then we can show through that evidence that 65 would be the normal retirement age within that business or in that industry or sector.
Okay. Here's another one.
Clemmy, extremely important question, please, man. Flores here from the Western Cape. Can you please ask your guests, especially on the farming, agriculture area, when people reach the age of 60 and they have worked for more than 10 years, then is that person then legally have the right to remain in that house on the farm? And then also, what other period for his spouse to live on after the main worker has passed on, and now his wife, does he has a certain period before she needs to vacate the house? Please, man. People on the farms here struggle, and I don't always have the answers for them. I'm a community worker here. Have a good job. Bye-bye.
Thank you. Advocate?
Yeah, so, I mean, that's a very loaded question. There's a lot of factors that one needs to take into account. If we look within the agricultural space, you may find that in many instances, there's either within the contract of employment itself, provision is made for the employee to receive housing as part of their remuneration package, if I can put it that way. So that would also then dictate what would be the circumstances in the event that the employee gets either dismissed, or if the person passes away, are there arrangements for their family to stay on or not? The question or the answer can be very different if there is, for example, no agreement that arranges that living arrangement as well. In other instances, there might be a rental agreement that exists. So one would have to look at all those factors combined before you are able to simply say this is that person's right or this is the person's family member's rights, and as far as continuing to stay there despite the person no longer employing there or having passed away.
Okay, and then someone else is asking a question about what happens when the age on the ID is actually your real age, and I know this because I've got the case with my parents as well, where the age stipulated on their ID was actually a mistake. How do you deal with that then? Is it a matter of going to Home Affairs and making sure that gets sorted, because it may affect you depending on what the approach of your employer is?
100%. So one would, if you know for a fact that the information contained on your ID document is incorrect, you also have a responsibility to ensure that you take steps for that to be rectified. And As long as you can show that those steps are also being taken, I do believe that it would be a factor that your employer may consider when you now reach retirement age, but it's not actually your age, because there is a provision also in the Labour Relations Act under Section 198B that stipulates that even when a person has reached the retirement age, the employer can still retain that person after retirement on a fixed-term contract of employment. So if this would be one of those circumstances, an employer may opt to say, listen, okay, I will retain you for 3 months or 6 months on a fixed-term contract, but if your issue is not resolved by then, I can't keep you. And so there are means for that, but you need to get it sorted.
Okay. Here's another voice note.
Good day, Clement and guest. I'm at the age of 64, and our company has stipulated in our contracts that retirement age is 65, and that will be at the end of my date of birthday date. So if I am going to have my birthday in July, then at the end of July, that is it. But then what happens thereafter if I'm still fit and well? Can I apply to the company, work on a contractual basis, or what are the options there? This is very interesting.
Thank you. Advocate?
Yeah, so normally most contracts would stipulate that you are required to retire at the end of the month in which you turn 65. But there's nothing that precludes an employer from retaining you after you have reached retirement age, if they do believe that you have a certain skill set and experience that they cannot immediately replace. So in those circumstances, there would normally be an agreement between the parties to retain for another year or two, or in some cases, the employer and the employee can engage with one another in an attempt to try and reach agreements on a new retirement age, potentially 70. But that ultimately would be something that both parties need to agree to.
That's great then, because there's still an opportunity for both the employer and the employee to negotiate, especially if both are happy with your, how productive you are in the company. The employer is convinced you can still work. You can agree on a different retirement age, both of you.
Yeah, because remember, whilst you and I may have an agreement at the inception of the employment relationship, circumstances change over the years, and nothing precludes us from changing that agreement and making amendments to that agreement. You often do have situations, though, where it becomes other employees that are not or don't receive the same indulgence may feel aggrieved, and they might feel that they are now being discriminated against for other reasons. So it's not very often, but in law, there's nothing that precludes the parties from agreeing to an alternative retirement age.
And then someone else also asking about what happens though when employees, how do you protect your rights if you feel pressured to retire earlier than you are legally required to? So if the legal age is, let's say, 60, but you're told maybe the employer just wants you out of the system even when you are 58, 59, how do you protect your rights there?
Yeah, I mean, you'll always have mechanisms and means to protect your rights. It's ultimately the employer's prerogative. If they're going to say to you that you need to now go on early retirement and they make the decision to terminate you, then they've made that decision. You can then follow the process of challenging that dismissal by going to the labour court and challenging that it was an automatically unfair dismissal. And that can be a very costly thing for the employer at the end of the day, because the employee can be awarded up to 24 months compensation if it's found that their dismissal is automatically unfair.
Sorry, please repeat that. They can be what?
They can be awarded up to 24 months compensation if it's found that their dismissal was automatically unfair.
Okay. All right. I think you've really helped us, Advocate Vessels, understand more about this retirement age and what people need to be aware of. Maybe before we wrap up, there's someone who's asking about, can an employer pay you less than what is due to you during a Section 189 process?
You can never be paid less than what you are legally entitled to receive during a Section 189 process, which is a retrenchment process at the end of the day. And there are certain prescribed payments that an individual should receive, which is obviously your salary up until your last working day, your accrued leave pay, and then severance payment, which in most industries is normally 1 week's severance pay for every completed year of service.
Okay, and then if you challenge that, because I imagine maybe this listener is asking because they're in that situation, what you approach, what's the CCMA, what's the next step? If you
Next step would be to make a referral, a severance payment dispute referral to the CCMA, or if there's a bargaining council, the bargaining council within that industry.
Yeah. Advocate, thank you so much for making time for us. Advocate Tertius Vessels is the Managing Director at Strata-g Labor Solutions. It's 11:30. Time for the latest in Eyewitness News.